Board of Ethics and Government Accountability to order. I'm Bega Chairperson Norma Hutcheson, and this meeting is being held at the Board of Ethics and Government Accountability at 1030 15th Street Northwest, Suite 700 West, and virtually. Joining me today for this meeting are board members Felice Smith, Darrin Sobin, and Melissa Tucker. Board member Charles Nottingham is appearing virtually. Together, the five of us constitute a quorum for this meeting. Since it was first posted, there have been no changes to the agenda, so I ask the board members to please take a look and review the agenda, and then we need a motion to adopt the agenda.
I'll make that motion.
Is there a second?
I'll second that. Second.
Okay, it's been moved and seconded that we adopt the agenda for today's meeting. All those in favor, please indicate by saying aye.
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 No opposed, no nays. Hearing none, the board has adopted the agenda for today's meeting. Also before us are the minutes from the draft minutes from the May 2025 meeting. And will a member please make a motion that we consider approval of those meeting minutes?
I'll offer the motion that we approve the meeting minutes from the previous meeting.
Okay. Is there a second?
Second.
Okay, it's been moved and seconded that the board consider the approval of the May 2025 meeting minutes. All those in favor, please indicate by saying aye.
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 Nay. No nays. Hearing none. The board approves the minutes from May 2025. Next on the agenda is a report from the Office of Open Government. We'll hear from Director Allen. Please proceed.
Thank you. Good morning, Chairperson Hutcheson and members of the board. I am Niquelle Allen, Director of Open Government, and I am pleased to present this report on the activities of the Office of Open Government, or OOG. Our mission is to ensure that all persons receive full and complete information concerning the affairs of the district government and the actions of its officials. Since the last board meeting, OOG has continued its work to ensure that the District of Columbia government's operations are transparent, open to the public, and promote civic engagement. To that end, OOG has enforced the Open Meetings Act, advised on the Freedom of Information Act's requirements, and provided trainings on these transparency laws. OOG has proudly served as advocates for an open and transparent government. First is Open Meetings Act and Freedom of Information Act advice rendered by the office. OOG issued 2 Open Meetings Act advisory opinions since the last board meeting. The first regarded the Criminal Justice Coordinating Council, or CJCC. Our matter number was OOG-2024-001. On February 6th, I issued a provisional advisory opinion, OOG 2024-0010, opining that the District of Columbia Criminal Justice Coordinating Council is a public body subject to the Open Meetings Act. Pursuant to DCMR Section 10405.2, I provided CJCC with the opportunity to respond formally to the complaint. CJCC provided a formal response on April 2nd that did not substantively address the legal arguments raised in the advisory opinion. The response requested that I address the issues with quorum that the public body experienced. As such, the opinion became final as of May 2nd, and I provided a response letter clarifying the issues related to CJCC's April 2nd letter. CJCC is currently excluded from the Open Meetings Act until July 6th due to Act 26-0041, the Open Meetings Clarification Emergency Amendment Act of 2025. I have concluded that the meetings of CJCC will be subject to the Open Meetings Act upon the expiration of the emergency legislation. A copy of the final advisory opinion that discusses the application of the OMA to CJCC is in Dropbox. The next matter concerned the Zoning Commission number OOG 2024-003. On May 8th, I issued this advisory opinion opining that the District of Columbia Zoning Commission's practice of holding standalone closed sessions violates the Open Meetings Act because its practice provides inadequate notice of the Zoning Commission's closed meetings and is inconsistent with the protocol that public bodies must follow to lawfully enter into closed executive sessions as set forth in DC Official Code Section 2-575C. The advisory opinion states OOG's position that the Commission cannot hold one open session at the beginning of a year-long meeting period, then conduct repeated closed session meetings thereafter, and be compliant with the Open Meetings Act. I found that the Zoning Commission displayed a pattern and practice of willfully participating in one or more closed session meetings in violation of the Open Meetings Act. The opinion also addressed the Zoning Commission's reliance on an outdated 2019 advice letter from the Office of the Attorney General Legal Counsel Division that advised that the Zoning Commission adhering to OOG's advisory opinions is not mandatory for OMA compliance. I clarified for the Zoning Commission that compliance with OOG's advisory opinions is necessary to avoid a civil enforcement action. I also made it known that OOG was ready to exercise its enforcement authority under the OMA if the Zoning Commission continues the pattern and practice as described, as the action complained of in the matter has the possibility of a civil fine. A copy of the advisory opinion and complaint have been added to Dropbox. Informal advice. Since the last board meeting, OOG has responded informally via email, telephone, or teleconference to requests for assistance as follows: 21 requests for Open Meetings Act advice, 9 requests for Freedom of Information Act advice, and 11 requests for technical assistance with open-dc.gov. Meeting monitoring. OOG staff attends public bodies meetings in person and remotely to ensure compliance with the Open Meetings Act. They also inspect public bodies' websites and the OOG central meeting calendar for public meeting notices and records. OOG's attorneys provide legal advice on OMA compliance and take corrective action if necessary. Since the last board meeting, OOG's legal staff attended 22 public body meetings, and as a result of the monitoring, one corrective measure was communicated. The public body failed to post a proper agenda pursuant to the regulations, meaning the agenda did not have the governing language. The training and outreach activity of the office is as follows. OOG's Local School Advisory Team Training Schedule meeting with the District of Columbia Public Schools representative. On May 14th, I, along with Chief Counsel Louis Neal and Attorney Advisor Joan Lelma, met with Sharona Robinson, Community Affairs and Engagement Manager, District of Columbia Public Schools, to discuss revisions to the Local School Advisory Team's training schedule to further accommodate the schedule of the LSATs, which comprise a specific number of teachers, parents, guardians, instructional staff, a community member, and sometimes a student. We aim to provide a training schedule that aligns with the school's academic calendar and LSAT elections. Making the Open Meetings Act simpler training. On May 15th, Attorney Advisor Anthony J. Skirbo presented the 4th training in OOG's Open Meetings Act training series for this year, titled Making the Open Meetings Act Simpler, to public bodies and their support staff. The training provided a brief overview of the Open Meetings Act with an emphasis on key questions and challenges that OOG has identified facing most public bodies. I, along with OOG staff, attended the training. National Associations of Attorney Generals Deposition Skills Training. On May 20th and May 21st, Attorney Skirbo attended this deposition skills training facilitated by the National Association of Attorneys General. The training covered how to do the following: develop a strategy for deposing witnesses, use best practices for discovering information from a deponent, and effectively defend a deposition through witness preparation and strategic use of objections. Effectively managing the DC FOIA process training. On May 20th, Attorney Joan Lelma presented this training on DC FOIA. The training provided an introduction to DC FOIA and covered how to do the following: respond to FOIA requests, searches for records, producing records, and preparing decision letters. I, along with OOG staff, attended the training. I responded to one of the attendees' questions about what measures, if any, will be put in place for FOIA processing if the current work operations in the district are disrupted due to the issues with the FY25 budget, which includes the possibility of furloughs and facility closures. I advised that this matter would be taken up by the mayor and DC Council, as was the case with pandemic-related facility closures. Center for Creative Leadership for the Peyton Leadership Academy Navigating Organizational Tensions program. On April 25th, Attorney Skirbo attended this training facilitated by the Center for Creative Leadership for the Peyton Leadership Academy. Participants considered the art of polarity management, a critical leadership skill that transforms seemingly irreconcilable tensions into strategic opportunities for organizational growth. The foundational framework of polarity thinking, teaching legal leaders how to identify, map, and leverage seemingly opposing forces with their teams and organizations. The litigation and legislative update is next. Litigation, Associated Press versus Taylor Butowich in his official capacity as White House Deputy Chief of Staff et al., case number 125CV00532 in U.S. District Court for D.C. The Associated Press, or AP, moved for a preliminary injunction against the White House Chief of Staff, Deputy Chief of Staff, and Press Secretary, collectively the government. AP sought to enjoin the government from denying it access to the Oval Office, Air Force One, and other limited spaces because of AP's viewpoint. On April 8th, Judge Trevor N. McFadden granted the preliminary injunction, ordering the White House to restore AP's access to press events. The judge found that the exclusion was unconstitutional and caused irreparable harm to the AP. The court found that the First Amendment prohibits the White House from excluding journalists from events based on their viewpoints. The order specifically enjoins the White House from excluding AP from the White House press corps because the AP refuses to relabel the Gulf of Mexico, the Gulf of America in its style guide. This is impermissible viewpoint discrimination. Even though the Oval Office is a non-public forum, viewpoint discrimination is still prohibited. Photojournalism and note-taking in the Oval Office are not pre-speech because the photographs taken there are transmitted to editors in near instantaneously, and print journalists sent out news alerts in real time. The government's decision to curtail the plaintiff's access to parts of the White House and the press pool event due to its editorial decision indicates retaliation and has adversely affected its ability to report the news and its business. The court granted AP's preliminary injunction request and moved on its own motion to stay the court's memorandum in order, imposing a preliminary injunction through April 13, 2025, to provide the government time to seek an emergency stay from a higher court and to prepare to implement the court's injunction. Absent further relief from the higher court, the stay automatically dissolves after April 13th. A copy of the court's decision has been added in Dropbox. Gooch versus District of Columbia Metropolitan Police Department, case number 2023 CAB-002404 in DC Superior Court. I have previously reported on this case in which a requester plaintiff sued the district for records related to his conviction. The plaintiff had received partially redacted records. The parties previously agreed to work on redactions, the Vaughn Index, and to provide updates at each status hearing. A status hearing was held on March 28th. Following the status hearing, the court issued an order directing the plaintiff to file a motion by May 12th, describing the request made for information, the information received that is still redacted, and the plaintiff's basis for why the remaining redactions are insufficient as a matter of law. The defendant was ordered to file an opposition on or before June 11th, including the unredacted documents for the court's review in camera. The plaintiff's reply is due July 11th, and motions hearings has been scheduled for September 2nd. On May 12th, the plaintiff filed a motion challenging the sufficiency of the defendant's most recent FOIA production. Copies of the court order and the plaintiff's motion have been added to Dropbox, and OOG staff will continue to monitor. DC Open Government Coalition versus the District of Columbia, case number 2023 CAB-007251 in DC Superior Court. I have previously reported on this case, which involves the DC Open Government Coalition's lawsuit against the district seeking an accounting of the backlog of public records requests submitted through the FOIA Express public access link. The plaintiff filed an amended complaint on January 24th. A status hearing was held on May 15th. Following the status hearing, the court set a briefing schedule for summary judgment. The defendant's motions and briefs are due by July 7th. The plaintiff's opposition and cross motion are due by August 4th. The defendant's opposition and reply are due by August 18th, and the plaintiff's final reply is due by September 1st, and a motion hearing has been set for October 2nd. A copy of the court's order with the briefing schedule has been added to Dropbox, and OOG staff will continue to monitor this case. The last case is Phillips versus District of Columbia, case number 122 CV 00277 in DC District Court. I have previously reported on this case in which Amy Phillips alleged in a federal Section 1983 action that the Metropolitan Police Department maintains a watch list targeting certain FOIA requesters. On March 10th, according to the party stipulation, the court ordered that this case be dismissed with prejudice because the parties reached a settlement agreement. A copy of the stipulation and docket entry notes of the order have been added to Dropbox. Next is legislative. First is legislative action regarding the Open Meetings Act. As I previously reported, Chairman Mendelson introduced Bill 26-200, the Open Meetings Clarifications Temporary Amendment Act of 2025. On April 1st, the council passed the bill on its first reading with council members Allen and Louis George voting against the measure. On May 6th, the council voted on the measure again with 7 members voting for and 5 members against. The bill was postponed to the next legislative meeting, and on Tuesday, June 3rd, the bill passed second reading by an identical margin to the first reading, 10-2 without amendment. U.S. Senate Bill 1450, introduced by U.S. Senator Mark Lee in April and referred to the Senate Committee on Homeland Security and Governmental Affairs, has not had any additional legislative action. This bill would repeal the Open Meetings Clarification Emergency Amendment Act of 2025, reading the Open Meetings Clarification Amendment Act of 2025, DC Act 2641 is repealed, and any provision of law amended or repealed by that act shall be restored or revived as if that act had not been enacted into law. A copy of the bill has been added to Dropbox, and OOG staff will continue to monitor. Legislative action regarding the boards of trustees for DC public charter schools. On January 17th, Councilmember Christina Henderson introduced Bill 26-0062, the Board of Trustees Training Amendment Act of 2025. The bill was referred to the Committee of the Whole on February 4th, and a public hearing was held on March 26th. The bill's introduction states that it aims to require public charter school boards in collaborations with the Office of the State Superintendent of Education to provide no-cost training for newly elected or appointed members of a public charter school's Board of Trustees. In response to the abrupt closure of Eagle Academy last August, leaving 362 students and the entire school staff without a school 1 week prior to the beginning of the school year, there are heightened concerns regarding financial oversight and board training within the charter school sector. The hearing had 3 experts, 14 public, and 2 government witnesses. Justin Lessig, Executive Director of Sojourner Truth Public Charter School, submitted that it is incredibly important that all members, regardless of committee participation or a specific area of expertise, also have a strong understanding of the Open Meetings Act and DC's Robert's Rules of Order. Sharon Boone Ruffin, a former Eagle Academy parent and former member of the Eagle Academy's Board of Trustees, submitted that ensuring that a board is properly trained can allow board members to pinpoint areas of mismanagement and identify issues before they become serious. This can prevent situations like what happened with Eagle Academy. In my own experience as a member of the Board of Trustees, Eagle Academy, we received very little training, and the training we did receive was primarily focused on policies around the Open Meetings Act. Though OMA compliance was not a centerpiece of the testimonies, it was referenced by numerous witnesses as a part of the required training on local statutes, regulations, and policies. The bill was marked up on on May 3rd, and with the committee report being issued on June 2nd. The notice of markup was filed with the Office of the Secretary on June 3rd. A copy of the committee report is available in Dropbox, and OOG staff will continue to monitor this legislation. The last legislative action is legislative action regarding a government agency's interpretation of its administering statutes and regulations. On June 3rd, the Council passed Bill 26-0048, Council Review of Agency Action Clarification Amendment Act of 2025. The bill, introduced by Chairman Mendelson on January 13th, passed unanimously on its first reading. The bill amends the D.C. Administrative Procedure Act in response to the Supreme Court decision in Looper Bright Enterprises versus Raimondo 603 U.S. 369 in 2024, where the court overruled the Chevron doctrine that had mandated courts to defer to reasonable agency interpretations of ambiguous statutes. This bill codifies the principle of agency deference in the District of Columbia and clarifies that a reviewing court or tribunal must defer to an agency's reasonable interpretation of a statute or regulation. This is the permanent version of legislation that the Council enacted in the fall of 2024 on an emergency and temporary basis. DC Acts 25-634 and 25-664. On March 6th, a public hearing was convened by the Committee of the Whole, and on June 2nd, the notice of markup was filed with the Office of the Secretary. The committee's public hearing record is available in Dropbox, and OOG staff will also monitor this legislation. Last in my report are administrative matters. I have one matter to report: the FY25 budget resolution and FY26 proposed budget. On May 27th, Muriel Bowser submitted her fiscal year 26 budget proposal. The proposed Bega budget reflected a 31.4% decrease in Bega's non-personnel services fund. This decrease was proposed as an offset to projected adjustments in the agency's personnel services cost. The DC Council Committee on the Judiciary and Public Safety indicated that will not hold a budget oversight hearing for Bega. Instead, the committee will send Bega questions regarding the FY26 budget. With respect to the FY25 budget, Mayor Bowser has sought to reduce non-personnel services expenditures to alleviate spending pressures caused by the continuing resolutions. There is a waiver process that is administered by the Office of the City Administrator to provide an avenue for agency to spend its non-personnel services funds. Bega has sought waivers to expend its fund for mission-critical IT expenses for OOG's website and training portal. Bega is in the process of gaining access from the Office of the City Administrator to its non-personnel funds for the continued maintenance and operation of open-dc.gov, which includes a central meeting calendar for all boards and commissioners and its parliamentary procedure training portal license. The payment for the website is due this month, and the waiver for this purpose has been partially granted. A copy of the proposed FY26 Bega budget chapter is in Dropbox for your information. This concludes the Office of the Open Government's June 5th, 2025 report. I'm happy to answer any questions the board may have.
Thank you, Director Allen. Are there any questions for Director Allen? Okay. No questions.
Thank you.
Next thing on the agenda, the next item on the agenda is a report from the Office of Government Ethics. We'll hear from Director Ashley Cooks.
Good morning, Chairperson Hutcheson and members of the board. I'm Ashley Cooks, Director of the Office of Government Ethics. I'm pleased to present this report on the activities of the Office of Government Ethics, OGE. First is an update on the status of OGE operations. The information reported today regarding OGE's cases will not reflect any status changes that may occur because of actions taken by the board during today's meeting. For open investigations by status, we have 49 matters that are open, one matter that is pending show cause hearing for a grand total of 50 open matters. For open undocketed matters, we have a grand total of 2. Pending state investigations by status, we have 35 matters that are closed pending collection, 2 matters stayed pending DC Superior Court case, 3 matters stayed for OIG investigation, 2 matters stayed for U.S. District Court case for a grand total of 42. For regulatory matters by status, we have 39 matters that are closed pending collection, 75 matters that are open for a grand total of 114. Again, we currently have 49 open investigations and 7 matters that are stayed. The number of open preliminary and formal investigations includes 8 new matters. The investigative team resolved 10 investigations since the board last met. This total does not reflect the number of complaints that were dismissed for a lack of jurisdiction. Last month, I reported that the quarterly complaint report for quarter 2 of fiscal year 2025 was published to the Bega website. The press release and heat map outlining the number and types of cases closed in the quarter were published shortly after, and a copy of the press release and heat map for quarter 2 are in the Dropbox. Next is an update on training and outreach. First is an update on professional development trainings attended by staff. Administrative Officer Naquita Titus took MS Office 365 Excel Part 3 offered by the DC Department of Human Resources. Investigator Ileana Corrales took Resilient Leadership offered by Harvard Business School online. General Counsel Rashi Raj took small business training for attorneys by the DC Bar's Pro Bono Center. LGBTQIA+ Cultural Humility, a Space for Queer Life, and the Council on Governmental Ethics Laws, COGL's Limits of the Law, Reflections on the Exercise of Power Using the Historical Record. She also attended the Emotionally Intelligent Attorney and Navigating Organizational Tensions by the DC Bar's John Payton Leadership Program. For trainings conducted by staff, since the last board meeting, OGE conducted 5 training sessions. That includes 2 new employee orientation ethics segments, the May monthly ethics training, a board and commissions training for the Citizens Review Panel, and the May Brown Bag session. Also, OGE conducted the quarterly outside employment training and an advisory neighborhood commissions training with the Office of the Attorney General, which was not included in the May report to the board. On Tuesday, May 27th, Attorney Advisor Maurice Eccles presented the May Ethics Counselor Brown Bag session on how to know when you're being lobbied. 18 ethics counselors attended the session, and a copy of the presentation was placed in the Dropbox. During the month of May, the Learning Management System registered 1,701 course completions. The training team has been meeting with LRN to discuss creating new courses and updating existing courses to make them more accessible to users. Last month, OGE started to identify low and underperforming courses to remove from our library of 29 available courses. For outreach, next week, OGE will issue its bi-monthly newsletter, Ethically Speaking. Next is an update on advisory opinions and advice. First is informal advice. OGE's legal staff provided advice for approximately 37 ethics inquiries, which is 16 more than the 21 reported at the May board meeting. This number does not include the responses we have provided to questions regarding the lobbyist and FDSE filing systems. For formal advisory opinions, OGE has 2 advisory opinions in the works on widely attended gatherings and an edited advisory opinion on advisory neighborhood commissioner sign-on letters. Next is an update on legislation and rulemaking. First is the Uniform College Athletic Name, Image, or Likeness Emergency and Temporary Amendment Acts of 2025. On May 6, 2025, Council Chairman Mendelson introduced emergency and temporary legislation that halts the financial disclosure requirements for board and commission members that were designated by Bega's September 27, 2024 rulemaking. The legislation provides that the rulemaking will not apply before January 1st, 2026. OGE expressed concerns to the council that the designated public officials meet the filing requirement because their duties and responsibilities create a financial conflict of interest or the appearance of a conflict of interest. I also expressed the extensive designation process that the agency undertook in evaluating and reviewing those designated boards and the extensive notice and training that were provided to them. Nonetheless, the emergency legislation was signed by the mayor on May 19th, And on this past Tuesday, the council passed the temporary legislation. Bega maintains its position that those board and commission members should be public financial disclosure statement filers as a means of government transparency and to ensure compliance with the ethical standards. Next is an update on the 2026 Budget and Budget Support Act proposals. The mayor submitted the FY26 budget and FY25 supplemental budget to the council on last week. Bega's FY26 budget pretty much remains the same, which includes an increase of $139,000 to align with personnel services and fringe benefits, and a decrease of that amount in the non-personnel services fund. The FY25 supplemental budget proposes to rescind $42,000 from Bega's local funds and $54,000 from the special purposes revenue. The proposed Budget Support Act includes severe changes to Bega's operating budget. The act will revert remaining funds in Bega's Ethics Fund and Lobbyist Fund, which are non-lapsing accounts, to the general fund. The ethics and lobbyist accounts are derived from revenue collected from ethics fines and lobbyist registration fees and fines. It was the council's intent when drafting our enabling statute that those accounts remain separate from the district's general fund. Since the creation of this agency, the ethics and lobbyist funds have been used to supplement the local budget and to maintain operations of the agency. Bega's local budget is insufficient to acquire the necessary services and personnel that are needed for the agency to operate. The special purposes revenue is currently used to support one FTE, the Learning Management System contract, employee training, and support services. The act not only affects Bega's fiscal independence, it also negates our ability to independently enforce the ethics rules within the executive and legislative branch of the government. In addition, the act also seeks to regulate independent agencies' telework policies to the discretion of the mayor. We plan to oppose these sections of the act. Given the constraints on completing the budget, the council has decided that Bega will not have an official budget oversight hearing. Instead, we will submit testimony and answer questions. I intend to provide written testimony on behalf of OGE and meet with council members to address these issues. Next is an update on the lobbyist registration and reporting. OGE is in the process of amending the lobbyist section of Bega's regulations to make technical changes and clarifying reporting requirements. Specifically, the amendments change the registration fee and the late filing fine to the new fee schedule that was implemented at the beginning of this fiscal year. The amendments would also include language that notifies registrants that the best course of action is to file a termination report when they do not intend on engaging in lobbying activity. The proposed rulemaking was posted on May 23rd, and the final date will be June 23rd. A copy was placed in Dropbox for your review. Next is an update on OGE administrative matters. Only one matter to talk about there, OGE's vacancies. OGE's vacancy announcement for the legal fellow position closed. Managers reviewed resumes and interviewed candidates. The hiring of the selected individual is contingent upon the ongoing budget situation. Bega will post its program support vacancy announcement as soon as possible. OGE has requested a waiver to hire for both of those vacancies amidst the citywide hiring freeze. Next is an update on financial disclosure statement, FDS. Pursuant to DC Official Code Sections 1-1162.24 and 1-1162.25, public officials and certain government employees must file a financial disclosure statement as a means of transparency and to prevent engaging in conduct that violates the Financial Conflict of Interest statute. Bega is responsible for ensuring that employees and public officials who meet the statutory requirement file their annual financial disclosure statement. The 2025 financial disclosure season has closed, and the FDS filing deadline was May 15th. OGE opened the season with 10,147 names in the e-filing system. 8,321 users filed by the May 15th deadline. Since then, an additional 395 filers have submitted their statements. We're in the process of receiving financial disclosure review reports from agency ethics counselors and sending notices to delinquent filers. Next is an update on lobbying registration and reporting, LRR. Pursuant to DC Official Code Section 1-1162.27A, a person who receives compensation or expends funds in an amount of $250 or more in any 3 consecutive calendar month period for lobbying shall register with the Director of Government Ethics and pay the required registration fee. According to DC Official Code Section 1-1162.30, each registrant shall file a quarterly report concerning the registrant's lobbying activity during the previous quarter. The first quarter activity reports were due on April 15th, and reminder notices were sent to delinquent filers on May 29th. The notice for the second quarter reporting will go out at the end of this month. The second quarter reporting deadline is July 15th. Attorney Advisor Eccles and Program Coordinator Kosick are planning another lobbyist training on June 15th. And the last update is public investigations. The matters there are 24-0016F and 25-0002F and Retrayon White. These are formal investigations based on 1, the criminal indictment in which respondent, council member for Ward 8, allegedly agreed to receive $156,000 in bribes and accepted $35,000 in cash from a business owner in exchange for assisting with renewing the company's violence interruption contracts with the district government. And 2, allegations that the respondent violated the code of conduct by failing to file a full and complete public financial disclosure statement pursuant to DC Official Code Section 1-1162.24. Investigation 24-0116F is stayed pending the outcome of the criminal court case, which is scheduled for trial on January 12, 2026. Thank you. This concludes the Office of Government Ethics June 5th report.
Thank you, Director Cooks. Are there any questions for Director Cooks?
I do. The Budget Support Act that's now looking at taking our O-type funds, which, by the way, has been a constant fight since the inception of this agency, and not just us. I mean, they try to do that every couple of years to all agencies because the mayor wants to have more direct control over the funds of the district. And at one point, there were so many O-type funds that it made sense. But in this case, it really is important for an independent agency like we are to have some control over its funds. I'm glad you're pushing back on that. The other thing is, I'm just curious, the part about the remote work policy, the budget support, is that focused on Bega or generally to all independent agencies?
It's focused on it. The language is that all agencies, so it's focused on all independent agencies, all subordinate agencies, to require them to follow the mayor's telework policy and to submit any proposed telework policy to the mayor's office for approval.
And so we have our own telework policy?
We do, because Bega has independent personnel authority, so
And
we
is it-
exercise our own.
How does it compare to the mayor's remote work policy?
I believe right now the mayor's remote work policy is 4 days in office, 1 day telework. We do 2 days in office, 3 days telework.
Okay, so there's some difference. And that's in the Budget Support Act?
Correct.
Okay. Okay, those are my questions.
Thank you. Any other questions for Director Allen? I'm sorry, Director Cooks. So the next item on the agenda is public comments. Members of the public in attendance at this meeting have an opportunity to make a comment at this time. Are there any? Everyone here is one of the Bega people. Okay. If there are no comments from the public, we will proceed to the next item on the agenda, and that's the executive session or executive or closed session. And this is a closed session to discuss ongoing confidential investigations pursuant to DC Official Code Section 2-575B14, to consult with an attorney to obtain legal advice and to preserve the attorney-client privilege between an attorney and a public body pursuant to DC Official Code Section 2-575B4A, to discuss personnel matters including the appointment, employment, assignment, promotion, performance evaluation, compensation, discipline, demotion, removal, or resignation of government appointees, employees, or officials pursuant to DC Official Code Section 2-575B10, to deliberate on a decision in which the Ethics Board will exercise quasi-judicial functions pursuant to DC Official Code Section 2-575B13, and to discuss contract negotiation strategies pursuant to DC Official Code Section 2-575B2. May I have a motion to enter into executive session?
So moved.
Is there a second?
Second.
It's been moved and seconded that the board enter into executive session. All those in favor, please indicate by saying aye.
Aye.
Any opposed? The motion passes unanimously. Board members, please move over to the boardroom for the executive session. We will return to this meeting after the conclusion of the executive session to report out on any matters decided, finish any other business, and to adjourn the meeting. Thank you. Okay. All right, the time is now 11:54 a.m. and we are back on the record. The board approved negotiated dispositions in two matters in 25-0001-F in Ray A. Lazada and 24-0124-P in Ray A. Smith. The board also approved a final decision and order in 24-0010-F in Ray Marcellus Willis. The time is now 11:55, and this concludes the meeting of the DC Board of Ethics and Government Accountability. The next monthly board meeting will be held at the Board of Ethics and Government Accountability at 1030 15th Street, Northwest Suite 700 West, and virtually on July 10th, 2025 at 10 a.m. Thank you. Meeting's adjourned.